Welcome, everyone. We'll give a minute for everyone to get out of the waiting room and into the webinar, and then we'll get started. Thanks for your patience. We're glad you're here. Still see people coming in from the waiting room, so we'll give it a couple more seconds before we get started. Okay, I see. I think we have everyone out of the waiting room. So welcome, everyone, and thank you for joining us today. My name is Mohsen Manesh, and I'm a professor and the Associate Dean for Faculty Research and Programs here at the University of Oregon School of Law. And it's my great pleasure to welcome you to today's Oregon Law Perspectives webinar. The Oregon Law Perspectives series brings the work of our faculty to our colleagues, our students, our alumni, and to the broader public. Today's session is the third and final in our 2025 summer series, and it's entitled Racialized Burdens and the Power of Rulemaking, Unraveling Discrimination in the Enforcement of Liquor Licensing. I'm so pleased to introduce our featured speaker, my colleague, Professor Angela Addae, to share her expertise on liquor licensing, laws, and race. Professor Addae is an assistant professor who specializes in the use of socio-legal qualitative methodologies to explore the intersections of race, organizations, and public policy. Prior to joining Oregon law, Professor Addae practiced as a litigation attorney, advocating for Oregon small businesses and large corporations. She is admitted to practice in Oregon state courts, the U.S. District Court for the District of Oregon, and for the U.S. Court of Appeals for the Federal Circuit. She also has worked with the American Bar Foundation, the U.S. House of Representatives Committee on Homeland Security, and the U.S. State Department. She currently serves on the executive boards of Oregon Consumer Justice and Abolish Private Prisons. Professor Addae will share her research on how administrative practices involved in issuing liquor licenses often reinforce long-standing patterns of racial exclusion. She will detail how these racialized administrative burdens shut out Black entrepreneurs, and she will offer some arguments for meaningful reform. For more on Professor Addae, please visit the Oregon Law Perspectives website. The plan for today is for Professor Addae to speak for about 45 minutes and then to take your questions at the end of her presentation. If you have a question, please feel free to use the Q&A feature on the bottom of the Zoom bar. Only Professor Addae and I will be able to see your questions, and they can be submitted anonymously if you so choose. We will attempt to get to as many of your questions as we can at the end of her presentation. For those of you who are seeking CLE credit, you will receive an email after the webinar requesting your bar number so that we can report your attendance back to the Oregon State Bar. Now, with those preliminary points out of the way, please join me in welcoming our speaker for today, Professor Angela Addae.
Thank you so much, Mohsen, and good afternoon to everyone. I really appreciate you being here today. Let's go ahead and get started. All right, so I'll just begin right here in Oregon. Over the past 40 years, local headlines have appeared in Oregon newspapers telling a familiar story. So I'm going to show you a few newspapers, and I hope that you might be able to identify a pattern here. Let's start with this one. This is from January 1984, the Portland Observer. And I've highlighted in the red box here, the city council votes no on lose license. Let's take a look at this one from October 1992. OLCC hearing on non-renewal of liquor license for Gabby's Restaurant to begin October 28th. How about this one, a double-decker? January 1999, last days of Cleo's. And that is referring to Cleo Lillian Social Club, which is a club on, or was a club on North Williams Avenue in Portland, Oregon. And then, you know, same issue, we have OLCC suspends Legends liquor license. What about this one from September 2000 in the Portland Observer? OLCC Council Cisco and Pancho's liquor license. March 2002, Formosa Cafe fights for survival. Front page of the Portland Observer. May 2003, Killingsworth Bar shuts down. June 2004, minority business hangs in the balance. June 2005, a year later, popular African American nightclub forced close. January 2011, dance club loses liquor license. October 2012, landmark bar to close. This is from the Scanner, another African American newspaper in Portland. DeWalt files motion in Fontainebleau suit, alleging that OLCC is conspiring against Black nightclub owners to put them out of business. And this is the follow-up to that article from April 2019. So if you read these articles carefully, you'll see that they oftentimes follow the same script. That's a Black-owned bar or nightclub or restaurant receiving multiple citations, sometimes for noise, sometimes for crowd size, sometimes for safety concerns. Then there's some sort of increased police presence that follows. Again, oftentimes with undercover visits, random inspections, extra patrols. Then liquor licensing renewal becomes a battle. Liquor licensing commission or the board might cite community complaints or some type of risk to public safety. The liquor license is denied, and eventually the business closes. When we read these individual stories, they all make sense when they're talking about standard public safety measures, and that's something that we all want for our communities, public safety. So when we read these individual stories and the reasons why these establishments are being shut down, they all make sense. But taken together, and when we zoom out a bit, it paints a picture that is hard for me to ignore, and that's these Black business owners facing really extreme challenges just to stay open. And unfortunately, these are not isolated incidents. They're part of this broader pattern that I'm exploring called racialized administrative burdens. This idea that delays, denials, and procedural requirements are justified through this language of neutrality, public safety often, but they in practice operate to exclude. So today I want to just connect what we've seen here in these Oregon headlines to cases from other jurisdictions, 3 in particular that we'll look at, where Black entrepreneurs challenged liquor licensing decisions through civil rights litigation. I use these qualitative analysis tools to reconstruct their experiences into focused case narratives. So I utilize newspapers, court filings, briefings, social media, etc., to see how race moves through the quiet, everyday inner workings of administrative decisions and administrative discretion. So these stories, hopefully, reveal not just how Black entrepreneurs are encountering and engaging with the state, but also how existing legal doctrines like federal civil rights statutes fail to capture these cumulative harms of bureaucracy, excuse me. So for me, it raises a deeper question. And for people who are studying belonging in the law, it raises a different question of what does it mean to belong in the marketplace? And in the law, what does it mean when the rules themselves can be weaponized against you? So I'll conclude with this idea that the most meaningful reforms are probably not those right now starting in the courtroom, but rather we need to look at overlooked processes such as rulemaking, where we can really engage with policy and procedure to reshape rights and protect rights before the harm occurs. So in my last project, which I encourage you to read if you haven't checked it out, I went into this deep historical dive where I found that the experiences of the entrepreneurs that we just looked at and the entrepreneurs that we're talking about today, they really aren't isolated to Oregon or even to our time. Rather they're part of this like centuries long phenomenon where there's this really complicated relationship between race and liquor licensing. So I'll try to give you a bit of a high level overview of what that looks like today. So um, in the pre-colonial era, all the way to the Civil War, liquor licensing was directly tied to property ownership, which of course was itself restricted by race. So under state law, only white male property owners could obtain a license to sell alcohol. This meant that liquor licenses were both sort of a marker of civic belonging and then also a tool for reinforcing the existing status quo. Who could own, who could profit, who could participate in commerce. So really liquor licenses and liquor laws more broadly served as a mechanism for social control. They policed the Black movement. They policed the Black presence in public spaces. They criminalized the sale of alcohol to enslaved Black people as well as free Black people. And then they also penalized establishments that allowed Black patrons to congregate, that allowed Black patrons to consume alcohol. So the underlying logic was one that are such that alcohol, property, public order, these were all privileges of whiteness, and the liquor licensing was a tool that merely just reinforced that. So this history is really relevant here because it reveals something that I think is quite fundamental about liquor licensing and liquor licensing laws, which is from the very start, liquor licensing wasn't about regulating a product. It was about regulating a people. And so deciding whose economic activity was legitimate was a core function of liquor licensing. So moving on to after the Civil War and the Reconstruction era, and more specifically the 14th Amendment, liquor licensing was kind of used to undermine Black economic and civic participation. So getting rid of the race specific laws after the passage of the 14th Amendment, liquor licensing regulators leaned heavily on racialized tropes, tropes that portray Black people as bestial or beast-like, meaning that they were dangerous under the influence of alcohol and therefore unable to control themselves, or that they were infantile and childlike, meaning they were incapable of responsible alcohol consumption. So these narratives and tropes justified liquor license denials, they restricted ownership, and they ultimately limited Black participation in alcohol related commerce altogether. So then moving through from the Reconstruction era, post-Civil War to the Jim Crow era, liquor licensing again was explicitly used to reinforce these narratives of segregation in public spaces. Lawmakers, licensing boards, the general public kind of treated establishments that served alcohol or served liquor to Black patrons as social threats. There was this fear, guided by these principles of segregation at the time, of interracial relations. So establishments that supported or allowed, drinking with people of mixed racial groups, specifically concerns about Black men patronizing and engaging with white women. So rooted in this racial purity ideology, rooted in these anxieties about political unrest. That's where these fears stem from. So Black bars, Black clubs, Black liquor serving establishments were frequently surveilled under under these anxieties. And then some of the anxieties were also around that of um, the pretext that these are spaces for revolutionary planning or revolutionary organizing. And to some extent, that's true. Those suspicions were grounded or well founded because, for example, there's a story about a restaurant in New Orleans that maybe some of you have heard of called Dookie Chase. And there's this notion out there that Dookie Chase fed the movement. Dookie Chase and his wife Leah Chase owned a restaurant in New Orleans called Dookie Chase, and it was actually a space where leaders like Thurgood Marshall and later Martin Luther King came to meet and also strategize and plan for a revolutionary civil rights movement. So these spaces were seen as social threats because they were spaces of revolutionary planning and organizing. And then moving to more contemporary times, today, of course, we don't see the explicitly race-specific laws, but we do see facially neutral regulations applied selectively. So this selective or hyper enforcement of liquor licensing laws oftentimes targets venues with predominantly Black clientele, and if not predominantly Black clientele, spaces associated with Black culture. So places that are known to play hip hop music, for example, or in some of the cases, we've even seen instances of clubs being targeted because they serve Hennessy, for example. So oftentimes the applications from these venues, they face greater scrutiny, sometimes outright denials, extremely burdensome conditions that drive up the operating costs to the point where they're basically intolerable by the entrepreneurs. So sometimes they might require they, as in the Liquor Licensing Commission and other regulatory bodies, might require um, police details or expensive security guards or advanced ID verification systems. And the result is ultimately a denial of personhood and a denial of agency. Black communities end up losing access to these spaces of recreation, third spaces, right? Spaces of joy, leisure, cultural expression. And so this is a challenge, right? Because this history shows us that liquor licensing has always been more than just a neutral, objective business regulation. It's been a tool for deciding who belongs in the marketplace, and some of those same dynamics are resurfacing through this notion of racialized administrative burdens. So, what exactly are racialized administrative burdens? This is a concept that's emerging out of the organizational sociology literature as well as the public administration literature. And it is a term that describes a very specific type of exclusion, which is one that happens through routine rules and procedures. So not your everyday kind of, not your, I'm sorry, more of your everyday inner workings, not necessarily like overtly racialized laws or policies. So this concept of racialized administrative burdens builds on two bodies of work. The first is Racialized Organizations Theory by Victor Ray, who's a sociologist. And Ray has this theory that organizations, all organizations, are racialized, meaning that organizations are never really race neutral. And so organizations in and of themselves are structured in ways that contribute somehow to the racial structure of the society, whether they reproduce racial inequality or work against it. Somehow they organizations, are operating in one way or another. They're contributing and they're engaged in the racial structures of society. So the racial organizations theory, along with the administrative burden theory, which is a theory promoted by public administration scholars Pamela Hurd and Donald Moynihan, um, suggests that bureaucratic processes in and of themselves impose certain costs. And those costs are learning costs, compliance costs, psychological costs. And so when you put these things together, the cost of engaging in bureaucratic processes and the racialization of organizations and institutions themselves, you can see how administrative processes like liquor licensing can carry racial impacts, even if no one is talking about race or thinking about race or explicitly engaging in race or racialized actions or processes. So what that looks like is routine requirements, inspections, applications, fees can ultimately be racialized and used as racialized weapons. Selective enforcement of certain rules, depending on who owns the business or who patronizes the business, shifting compliance requirements that keep applicants in perpetual limbo, burdensome licensing conditions. And by the way, we're talking about this in the context of liquor licensing, but you can imagine other frameworks and other scenarios in which this could also play out. Accessing public benefits, for example, is another space in which this is primarily talked about. So that's the framework that I'm using, and I just want to show you how it looks like, what it looks like on the ground. Like, I'm going to use these three focus case narratives to reveal how administrative burdens, or these racialized administrative burdens, work in practice. You have to have a joke. So this is my joke. Three entrepreneurs walk into a bar and straight into a wall of red tape. So to understand how these burdens operate, I studied three cases where these Black entrepreneurs took the step of challenging these liquor licensing decisions through civil rights litigation. Um, I use, again, qualitative tools to reconstruct these experiences in detail. And I just want to echo that these narratives that we'll talk about moving forward are from other states, but they do echo exactly what we see here in Oregon and what I showed at the outset of the presentation. The difference is that in these cases, the business owners fought back through litigation, federal litigation. And so that, I think, gives us a window into how the system justifies itself, but also how we might reimagine it. So I selected these three cases, moving forward, it'd be Quarterman, Sheba, and Volcano. And I selected them for a few reasons. One is they each come from a different jurisdiction. One is from Massachusetts, one is from Georgia, and one is from Alabama. And these three different jurisdictions show us that racialized administrative burdens are not confined to one state or one regulatory culture. Specifically given that liquor licensing is something that happens at the state level. So if we looked at all in one state, we might say, oh, that's an Oregon thing, or oh, that's a Georgia thing. No, it's a thing more broadly. So we'll look at it from across different states. Secondly, they all involve different mechanisms of exclusion, which for me makes it harder to detect, right? If we saw the same thing happening in each place, we can say, oh, when they do that, that's a racialized administrative burden. But examining the different ways in which racialized administrative burdens show up will allow us to kind of navigate the reform a little bit easier. And then third, these cases were chosen because they're all civil rights cases litigated in federal court using federal civil rights statutes. So Section 1981, Section 1983. And that means, one, it gives them some space to kind of look at the civil rights statutes themselves, but also there's a detailed record related to the pleadings, the evidence, the judicial reasoning that lets us see exactly how race moved through the administrative process and how the courts responded. And then finally, I think that these three cases that we'll look at are exemplary because they reflect common patterns that I found in my broader research. So though we're talking about three cases today, I've actually closely examined over 50 federal cases where these patterns, these same patterns that we'll look at today, are echoed in newspaper accounts and um, licensing board minutes and community testimony. And so I've looked at 50 federal filed, and litigated cases, but probably hundreds of, other unfiled, unlitigated cases, scenarios, situations, challenges related to liquor licensing. All right, so the first case we'll start with is Quarterman versus City of Springfield. And I have the term here, weaponizing neutrality. So one of the defining features of racialized administrative burdens is how regulators can manipulate procedural requirements to justify the exclusion. So in this way, the discretion works both ways. It works as a sword because it allows departures from the normal rules, but then it also works as a shield because discretion can protect decision makers from accountability because they say, oh, you have discretion to make these decisions. So that's exactly what happened in Quarterman versus City of Springfield, where you had this entrepreneur, Will Quarterman, who is a bar owner and sought to open a venue catering to predominantly Black and Latino patrons. However, the application process was just completely, I'm going to use a technical term here, wonky. Instead of the standard procedures, his application was subjected to all sorts of irregular investigations. They tried to dig up whatever they could on him. And even on the record, one of the board chairs said something to a colleague like, if you can't find any dirt on him, try the back door to find damaging information, meaning, check with his vendors, check, underneath the rug, wherever you can find damaging information to support the denial of this application. And then, of course, there were some racialized comments as well, including a member of the commission warning Mr. Quarterman against playing hip hop music, and also making some sarcastic remarks about, oh, you're going to get support from groups like the Urban League or the NAACP. Nonetheless, Mr. Quarterman's liquor license application was denied. And Mr. Quarterman brought this to federal court and made an argument that this was a racially discriminatory process where they denied his license on the basis of race. But in order to support his claim, he had to show that, that there was racial discrimination. So he argued that the fact that they targeted him for playing hip hop was a proxy for targeting him for race. Unfortunately, the court rejected this argument, and the judge had some colorful commentary about how hip hop is really popular among white audiences. And I thought it was very funny that the judge also referenced Drake as evidence that, hip hop is really popular. In fact, Drake is biracial and Mr. Quarterman is also biracial. And so the court said, oh, there's this new Canadian rapper. And that shows that he's also, that hip hop has this wider popularity outside of predominantly Black audiences. But despite all of the commentary, I think that the Quarterman case illustrates a doctrinal problem, which is that substantive due process claims, of course, require a conduct that shocks the conscience, and equal protection claims require a proof of intent. And racialized administrative burdens are cumulative, they're structural, but more importantly, they're facially neutral, which means that they oftentimes escape constitutional scrutiny altogether. And so when we're thinking about solutions, it makes sense that the solutions will have to come from policy or rulemaking where procedural safeguards can be built in before the harm occurs. Okay, the next case is Sheba versus DeKalb County. So it's Sheba Ethiopian restaurant. It's a Black-owned Ethiopian American restaurant in Georgia, or in Atlanta, DeKalb County. And this venue is an example, or this venue's case is an example of what I call the weaponization of racial invisibility. As I led with, Victor Ray has this notion that all organizations are racialized, but that's, while great, sociological organizational theory, doesn't necessarily translate into law. So this venue, the restaurant that turns into a late night venue, usually these spaces have hookah and things like that. So in 2015, you had this white real estate professional who launched a campaign to get rid of noxious uses in the area, specifically targeting these Ethiopian restaurants with the hookah bars. Her complaints gained some traction, especially with the county commissioners. And ultimately, the county commissioners directed staff to investigate. And that just resulted in a wave of like an influx of inspections, citations, enforcement actions. If you look at the complaint, it's probably 80 pages long because there's just one thing after another. So the challenge here is that a lot of the non-Black businesses who had the similar violations were still allowed to remain open, whereas the Sheba Ethiopian restaurant ultimately lost its liquor license, lost its occupancy permit, and lost its business license. So Sheba's owner sued again under federal civil rights law, and this case made it all the way up to the 11th Circuit, where the 11th Circuit weighed in on this idea of organizations having a race. And so the 11th Circuit basically said that it was not clearly established that corporations could have a race, and therefore the city officials were entitled to qualified immunity. Now, this isn't a nationwide conclusion, because there is a circuit split. Some circuits have concluded that organizations can have a race, but at the time, it was not well settled in the 11th Circuit that organizations or corporations could have a race. And so because it wasn't well settled or clearly established law, there was no civil rights claim. So this is interesting to me, not necessarily because of the court's the court's conclusion, but really because of the dilemma here, which is that the court refused to recognize Sheba Ethiopian restaurant's racial identity, despite its Black ownership, Black customer base, and the racially motivated campaign against it. But this business was visible enough, racially visible enough, to police, to sanction, to shut down, but it was invisible when it came to receiving the protections of anti-discrimination law. So again, showing the limitations of the federal civil rights statutes. Okay, so the third case here is that of Volcano Enterprises versus City of Huntsville. And this case is a clear example of weaponizing compliance. So imagine we've already talked about weaponizing neutrality, we've talked about weaponizing invisibility, and now we're talking about weaponizing compliance. So 3 different strategies of exclusion. And so in this instance, this is where regulatory requirements become an endless shifting target that an applicant can never quite hit. So this happened to Mr. Daryl Williams of Volcano. So he leased a site of a place called the Silver Dollar Lounge, which was a adult club. It was a white-owned adult club that had operated for about 40 years in Huntsville, Alabama. So he took over the space and he applied for, the same license that was previously at the space in the same exact site. And from there it was just quite tumultuous. But basically the license review committee, the city council had a series of failures, compliance failures, unpermitted work, code violations, police data tied to the previous tenant. And so Mr. Williams spent about $50,000 to resolve the issues that kept coming up to try to comply. So he every time something new came up, he would comply, comply until he didn't have any more money. So he addressed the earlier denials, he secured a certificate of occupancy, he corrected the cited issues, but just new justifications emerged each time. And so the effect was that compliance was never really stable. Each time a box was checked, another requirement came up or appeared. So, I mean, as you might imagine, this moving target approach effectively locked Mr. Williams out of the market. So even though he was seeking the same classification in the same space as a previous club, he had all these challenges, and as a result, brought a discrimination claim in federal court, a civil rights claim in federal court. So he brought claims under Section 1981 and 1983 for selective enforcement. And to be successful on a selective enforcement claim, you have to show that one, you have membership in a protected racial group. There was intentional discrimination on the basis of race. That discrimination involved a protected activity. So here, that protected activity was the right to contract. And then there was a similarly situated comparator of another race who was treated more favorably. So Mr. Williams met the membership in a protected group requirement. He met the discrimination involved the protected activity requirement, but he didn't quite meet the intentional discrimination requirement, nor did he meet the similarly situated comparator of another race requirement. And he couldn't improve, and saying he couldn't improve that another person, another similarly situated person of a different race was treated better than him. And again, this kind of shows the gap or deficiencies in litigating. These people felt like they were litigating Section 1981 claims and Section 1983 claims, but from my view, they were really litigating or challenging racialized administrative burdens. And so the problem with that is that racialized administrative burdens layer these facially neutral requirements, the code compliance, the security plans, the zoning, and then shift the standards each time an applicant meets them. So when by the time the dispute gets to court, there's no way that they can have a comparator because this is a cumulative pattern of moving targets. So it's effectively legally invisible. So just kind of thinking through, what do we do about this? How do we address it? As I mentioned, federal court doesn't seem to be the way right now. The problem with relying on Section 1981 and Section 1983 is it's structural, right? That these civil rights statutes have been interpreted to catch intentional discrimination, not these procedural cumulative harms that racialized administrative burdens create. So it means that courts can acknowledge that something feels off, and they do, right? Like the judge in Quarterman acknowledged that something feels off, but they still deny relief. And so that's why I think it's important to turn to administrative rulemaking, because it allows us to proactively change the decision-making framework earlier in the process. And I think that a useful example comes from Washington State Court. So the General Rule 37, which was created to address racial bias in jury selection. after their Batson challenges kept failing. And so the Rule 37 does something that's subtle but quite powerful, because it acknowledges that one, bias can be implicit, it can be institutional, it can be unconscious. So it kind of gets us over that intent hurdle. But then it also applies this objective observer standard, which basically asks whether a reasonable person, um, who is aware of these biases could see race as a factor in the decision. And then it lists presumptively invalid reasons that have historically been used as pretext for exclusion, which we have the history, we have the historical backdrop. So it's possible that liquor licensing agencies and commissions and boards could adopt similar rules, um, that prohibit racial proxies, for example, or at least have a closer look at racial proxies like music genre or decor or neighborhood as justifications for denial. Um, that they could require written, evidence-based findings for each decision, which are tied to some type of clear criteria, that they could publish enforcement data by race and geography to make these invisible patterns more visible, and then of course adopt an objective observer standard so that if there is this implicit or unseen bias, it's recognized as a grounds for reversal of these liquor licensing decisions. So I think I can pause there, looking at the time, and look forward to your questions. Thank you.
So thank you, Angela, for that. If you have questions, now would be the time that you can use the Q&A button at the bottom of your Zoom bar to submit them. Angela, let me ask you a question. And maybe the answer is you haven't looked into it, but I'm curious how much of the story that you see that's played out in the history of liquor licensing also play out in the context of cannabis licensing, both perhaps, well, maybe we know the racial disparities in enforcement when cannabis was prohibited, but now as we've seen it legalized in various states and licensing to engage in growing and selling cannabis, I wonder if you're seeing similar patterns in that context that you've seen or established in the liquor licensing context.
So one is I haven't looked directly into liquor license, I mean cannabis licensing, but I do know anecdotally that some of these issues were preemptively addressed in even legalizing cannabis. So in certain jurisdictions, they acknowledged that there was this history, and they preemptively sort of tried to correct for it. And something like that could actually be applied in the liquor licensing context, because what the history and the sort of the data around racial disparities in cannabis and cannabis enforcement and all of those things played a role in how the policies were developed to begin with, right? To shield or protect communities from perpetuating or reinforcing these disparities. And so I think having that historical backdrop, front and center in even the policy development and policy discussions was so important in prohibiting or preventing the perpetuation of it. And so that that same history and the same historical knowledge and background is not as, I don't think is as well known in the liquor and liquor licensing context. And so I hope that by kind of illuminating this history of this relationship between racial discrimination and liquor licensing, we'll start to build in some of these corrective mechanisms in the policymaking process.
Yeah, that's interesting because that is consistent with kind of my own observations, which is that as part of the legalization movement and the licensure movement for cannabis, racial and social justice have been there at the outset, and so you've heard and I've seen all sorts of schemes where people who have been convicted of cannabis crimes are either given priority for licenses or are given some kind of benefit based on cannabis sales as essentially a way to restore the harms that have been done in the past. And what I hear you saying is that we don't see the same thing in the liquor licensing context, and it's in part because that history of disparate racialized enforcement just hasn't been established in the way that it's been established and recognized in the cannabis context.
Yes, and I'll also add that there's a unique relationship with uh, liquor and alcohol in Black communities seen as it's a vice, right? It's it's not front and center for the social justice movement in terms of promoting and perpetuating uh, the proliferation of alcohol and access to alcohol in the community. So part of it is also a reframing around alcohol itself and the community's relationship with alcohol and seeing these spaces as valuable contributions to the community, not deteriorants of the community because, or I say establishments that deteriorate the community because they are, third spaces that offer places of employment, places of economic activity, social spaces, places where youth kind of engage in cultural expression. All these things are healthy mechanisms for the community. So I want to make sure that there's also acknowledgement that alcohol and alcoholic related venues have been seen historically as harmful,
Mhm,
while also acknowledging that there is some benefit when regulated in a healthy way.
mhm. Thank you for that. So we had a question come in through the Q&A. Have you engaged with any state agencies to discuss your findings and proposals? And if so, how were they received?
Not yet is the answer to that. That's definitely on the radar for me, and I would love to engage in the rulemaking process here in Oregon to propose some modifications for the OLCC in particular, because as you've seen at the outset of the presentation, Oregon is not immune from these I'll just say outsized responses. There's not very many Black owned establishments in Oregon, let alone when you think about the disparity in how much enforcement activity is centered around the Black owned establishments. And so I hope to work in the future with the OLCC to mitigate some of the harms, and support Black entrepreneurs who are hoping to, bring jobs to their communities, create spaces of entertainment, create spaces for youth to be safe. Because all of these entrepreneurs, some of them I've done interviews with, they all have the same interest, which is to have safe, safe spaces for their community members to recreate ultimately. So they are also sometimes victims of the social circumstances of their communities when it comes to things like gang activity and gun violence and drug activity as well. So they want clean streets, clean neighborhoods, clean establishments, so that they can provide um, safe spaces for the people that they love.
Your response made me think of two different questions. I'll just ask them separately. First, how do you choose which entrepreneurs? How do you identify and then ultimately choose which entrepreneurs to profile in your paper?
Um, Part of it is stemmed from the litigation, and then I sort of snowball from there. So for example, there are three federal lawsuits in Oregon that I'm aware of. Um, One is an adult club, one is two are nightclubs, and they all have similar stories. And so I reach out to one, and they say, "Oh, this happened." They all are in the same community, so they know each other, and it's this happened to so and so, and you should talk to so and so. And so using this sort of snowball method allows me to not only kind of deep dive into particular issues, but have a broad range of experiences across both, you know, industry, I guess you could say, in terms of the types of establishments they have, but also in terms of time, because some of the entrepreneurs try again, right? They did this establishment didn't work out, so they'll start another. But some, had their venue shut down, 20 years ago and never attempted another entrepreneurial endeavor. And it's because they invest a lot of money, and they lose a lot of money. If your liquor license is revoked, then you suddenly are in breach of your lease agreement in the building, for example. Suddenly you are indebted to your vendors who provided your products, and most of them also are have to serve food, so there's like restaurant, there's stock and all of these things. So there is a huge loss, it's a huge economic blow, with something that is as simple or seems seemingly mundane as getting your liquor license revoked. So, but it's a huge, tremendous cost to these entrepreneurs. So they all know each other, at least here in Oregon. But usually outside of Oregon, community members also are helpful in identifying spaces that they know of that have been closed down. And also the media is usually picks up on, as I showed you in the newspapers, they pick up on these instances as well.
Although I'll note that I think all of the news clippings you showed at the beginning, which I love to see that series, were all black newspapers, right? And so I wonder if you even see similar discussions in the Oregonian or whatever other newspapers that have a more general audience. Second question deals with, again, coming back to Oregon and the I-5 corridor, Eugene, Salem, and Portland. I think we think of ourselves in this area of the country to be racially progressive, and that's in part because we know that there's a history of racial discrimination in the not too distant past here in Oregon. Have there been any reforms at the state or at the county or municipal level here locally that you see as positive reforms that should be emulated by other jurisdictions, or are we as behind as everyone else, or behind other jurisdictions in recognizing and trying to address this pattern of discrimination?
No, Oregon has a lot of great initiatives that are in support of Black entrepreneurs. I'm hesitant to name them because some of them are being in the stage of retrenchment right now.
Mm.
But historically,
And is that because of federal intervention or things happening at the state or local level?
a little bit of both.
Okay.
A little bit of both. But historically, Oregon has been quite ahead of the ball when it comes to recognizing the one historical just disparities and remedying them. So in terms of state programming, also local programming, the private sector has stepped in, philanthropy has stepped in, the nonprofit sector has also stepped in with grants and things like that. So almost every sector of society in Oregon has contributed to the betterment of the Black-owned businesses. And that to me is why I do this work here, because I think that it's fun to be on the winning team. Um, when we think about and identify issues related to Black-owned businesses, and there's a possibility for success in identifying a problem and hoping and having some type of optimism that it will be addressed. And so here in Oregon, particularly in Portland, but not necessarily centered in Portland, because at the state level, even during COVID, there was particular attention, like the Oregon Cares Act, for example, which was um, a COVID intervention that supported directly Black-owned businesses. So there are quite a bit of initiatives. As of course, the the nonprofit sector, lots of grants and other supplemental resources, assist Black-owned businesses. A lot of places. Well, a lot of this work came from emerged from my work on gentrification and looking at urban renewal in different communities. And so the people that were most impacted, apart from the residents were the businesses. And so turning attention to the needs of the commercial residents um, was something that emerged out of this work. And so a lot of the right to return and revitalization of historical neighborhoods also gives some attention and resources to Black-owned businesses in Oregon. So really positive reform efforts so far, and I hope that that momentum continues.
One final question, Angela. For the attorneys and students in the audience, one message I hear you saying is that the nature of civil rights law makes it inadequate to use it as a litigation tool to address these kinds of disparate impacts in liquor licensing. Um, to end on a note of hope, what can attorneys or students do to advocate for change in this area if litigation is proven to be an ineffective tool for reform?
So litigation can be an effective tool for reform in lots of different areas. And in fact, much of the civil rights progress um, manifested through litigation. Like that was sort of the cornerstone method of those historical um, civil rights activists. They definitely leveraged the power of the courtroom for specific types of redress. Here, litigation is not the most adequate avenue because of the ways in which federal civil rights statutes have been adjudicated, essentially. Um, so so for the lawyers and the students, it's the exercise of creativity, which I think is always that of a lawyer, right? As of a zealous advocate is a posture of creativity. And that's how we even got to be where we are today, because the civil rights activists engaged in very creative legal maneuvers to create the civil rights framework that we have today. So it's always going to be thinking outside of the box, utilizing the tools that we have in a different way to advance civil rights goals. And so that's what I encourage students to do, encourage attorneys to do.
Well, on that note, let me thank you, Professor Addae, for leading us today through this thought-provoking presentation and discussion. And thank you to everyone in the audience for tuning in. This marks the end of our 2025 Oregon Law Perspectives Summer Webinar Series. We hope to see you again next summer for another series of illuminating and informative Oregon law perspectives. Have a great afternoon. We'll see you next summer.